Good morning. I want to welcome everyone to Lone Star Legal Aid's Vet Week presentation. This week, today's presentation is going to be on service-connected benefits and non-service connected benefits. I just want to go ahead and turn it over to my partner, James Meredith. He does have something to inform everyone about before we get started.
Hi, good morning. Just as a short kind of a disclaimer, this presentation is intended to serve as legal information and does not replace legal advice. Contact Lone Star Legal Aid at 1-800-733-8394 or go to lonestarlegalaid.org for more information on legal assistance. For those of you in the chat that are veterans and you have maybe a more veteran-specific issue, you can contact us Monday through Friday, 9 a.m. to 4 p.m. at 1-844-400-VETS. You can also email us at vethelp@lonestarlegal.org. Thank you.
All right, welcome everybody to today's Vet Week presentation here by Lone Star Legal Aid's Military and Veterans Unit. Again, today is going to be on service-connected and non-service connected benefits through the U.S. Department of Veterans Affairs. So in order to file a VA claim, you're going to need to fill out the appropriate form, which is VA Form 21-526EZ. That is the application for service-connected benefits through the VA. You also want to submit any post-service treatment records. That's especially important if it's been more than 1 year since you're discharged from active duty and you're filing a claim. A copy of your DD-214 is always helpful. That way they can go ahead and verify your service. A copy of any of your service treatment records if you have them. Although the VA will go out and obtain them, if you have them and give them a copy, do not send them your only copy, a copy of what you have. Send them to the VA. That can just help to speed up your claim. And then any personal statements from family, friends, or military service members that you may have served with that you feel are pertinent to help your claim. Go ahead and get all that stuff together, and you want to submit that to the VA. The fax number or mailing address will be on that 21-526EZ form on where you're going to want to send all that information and evidence to. So if you're already service connected for something, you already have a percentage, whether that's a 0%, which is service connected. It just means that that disability was not severe enough to warrant a compensable evaluation. Or if you're at 20 or 30% and you feel that your disability has increased in severity, you can file a VA increase claim to try to increase your disability percentage. Again, you're gonna do that on a VA Form 21-526EZ. Submit any medical evidence that you have that might help prove your claim, especially if you have private treatment records. The VA will go out and attempt to obtain those private treatment records. However, they only attempt twice. And then after that, the onus is on the veteran to go ahead and make sure that the VA has those private treatment records. If your treatment is at the VA facility, then you just need to inform the VA of what VA facility that treatment is at and those years that you were treated there. And by law, the VA does have to go out and obtain those treatment records from the VA. If it's been more than a year since your last compensation and pension exam, then the VA will schedule you for another compensation and pension exam. You do need to attend that exam. That is one of the main pieces that the VA uses when assigning a disability percentage. And then in order to receive an increase in your VA disability, your disability must meet the rating criteria for the next higher evaluation of that condition in the VA rating schedule, which you can find online under 38 CFR Part 4. Now, we have another benefit called individual unemployability. In order to apply for individual unemployability, you want to submit VA Form 21-8940. That is a specific form just for this benefit, just for individual unemployability. You can only claim service-connected disabilities that hinder you from being able to obtain or maintain substantially gainful employment in order to receive this benefit. In order to be granted this benefit, you must meet certain rating criteria. For instance, you have to have a single disability rated at 70% or multiple disabilities, with one being at least 40%, and additional disabilities that make the total at least 60%. Now that's a regulation. You have to meet that in order to be granted this benefit. If you do not meet that criteria, unfortunately, the VA will not be able to approve that claim. The threshold for this benefit is extremely low compared to that of Social Security disability. And also remember that just because you get a grant for individual unemployability does not mean that Social Security is going to automatically grant your Social Security disability claim, since the SSA has different criteria for granting their benefits. Although you will want to submit that rating decision to Social Security that does show that you did receive that benefit, as that would be a valuable piece of evidence to help your case for your Social Security disability claim. So then we have presumptive disabilities. So the VA recognizes disabilities that are caused by service, but may not have actually arisen while you were on active duty or treated or diagnosed while on active duty. So these presumptive disabilities can be anything that are related to Agent Orange, Blue Water Navy Agent Orange, which just went into effect last year, radiation exposure, if you're a prisoner of war, the Gulf War environmental hazards, and then there's some general presumptive disabilities that if you get diagnosed with certain disabilities within a certain time frame after your discharge from active duty, the VA will presume that those disabilities are related to service. For instance, diabetes, if it's diagnosed within 1 year of your discharge from active duty and it's diagnosed to a compensable degree within that 1 year of discharge from active duty, then the VA will presume that that condition is related to service and will service connect that. So Agent Orange. So the Agent Orange Act of 1991, that established provisions for the National Academy of Science to analyze and summarize scientific evidence regarding presumptive military service exposure to defoliants, dioxins, and herbicides, better known as Agent Orange, during the Vietnam War era. Now, where do you need to have been exposed to these? Obviously, Vietnam or the inland waterways. The VA will refer to those inland waterways of Vietnam as the brown waters. So a lot of times it used to be called like the Brown Water Navy. If you were considered in the Brown Water Navy, they considered you as being boots on ground in Vietnam. Now that they've extended that presumption to Blue Water Navy veterans, now if you were on a Navy ship in the waters offshore of Vietnam, there's certain presumptives that you can get. Obviously, you have to be within a certain radius of the shore of Vietnam, which the VA has all those guidelines set forth for them and what they're going to go by in order to see if you were within those guidelines and within those certain boundaries in order to be considered as a Blue Water Navy veteran, as someone exposed to Agent Orange. Also in Thailand, if you're a military occupational specialty, put you on or near the fence lines of the bases where the spraying was known to happen. Most commonly, these jobs would be like your MPs or your security police if you're in the Air Force. They're the ones who would most of the time would patrol the outside perimeters of the base or the inside perimeters of the base where a lot of the spraying went down. On or near the Korean DMZ from September 1 of 1967 until August 31st of 1971. Or on or near other smaller and lesser known locations and instances on case-by-case basis that are going to require a more in-depth investigation by the VA. And also, you're going to need to have a diagnosis of a medical disability found to be related to Agent Orange. The most common one is diabetes mellitus type 2, and also coronary artery disease is another one that's a big one as well. You're going to need to meet the requisite military discharge and service requirements for benefits should be included when you're filing the claim. So again, you're going to need to have a discharge that's other than dishonorable. So you need to have an honorable discharge or a general discharge. And then obviously your service requirements, meaning service in an area where there was known to have been Agent Orange. You're going to need to state on your application, that application's that VA form 21-526EZ, that you are filing for one of the conditions related to presumed herbicide exposure, such as Agent Orange, and then provide some medical evidence showing a diagnosis of a current condition related to exposure. So again, for example, if you're saying you have diabetes mellitus related to Agent Orange, if all your treatment was at the VA hospital, just let them know, hey, I was treated at the VA hospital. I have a diagnosis from there. By regulation and by law, the VA will go and pull those. As long as they see that you have a diagnosis of diabetes and you have that honorable discharge, and there's proof that you were somewhere where Agent Orange was sprayed, then they'll get you that compensation and pension exam. And then from there, they'll make a decision on your case after those results are received back. So the Blue Water Navy for Agent Orange. So Public Law 116-23, which is the Blue Water Navy Vietnam Veterans Act of 2019, was signed into law on June 25th, 2019, and it took effect on January 1 of 2020. So this law extends a presumption of herbicide exposure to Blue Water Navy veterans who served in the Republic of Vietnam and the offshore waters. Blue Water Navy survivors and certain dependents may be entitled to benefits if the veteran was exposed. You must have a diagnosis of a medical disability found to be related to Agent Orange per the VA guidelines and meet those requisite military discharge and service requirements for those benefits as well. What should be included when you're filing the claim for Blue Water Navy Agent Orange exposure? Again, you're going to want to state the disability you're claiming and that it's related to Agent Orange. Include any evidence you have of service in the offshore waters of the Republic of Vietnam during the required time frame. You're going to want to include the name of the vessel and the dates you served within 12 nautical miles of the Republic of Vietnam if you have that information. Most likely, if you'll just give them the name of the ship you were on and the dates you were assigned to that ship, there is a database that the VA can use. They'll go pull it up, see when was that ship over there, were they within 12 nautical miles, and then the VA will take it from there based on their research and what they're able to find out about the ship that you were assigned to. And then again, you'll want to provide some of that medical evidence showing a diagnosis, especially if it's medical evidence not from the VA. Again, if you did get your treatment at the VA, just let the VA know on that VA form 21-526-EZ what VA facility you went to and what those years of treatment were, and they will go and pull those records to look and ensure that there is a diagnosis of a presumptive disability related to Agent Orange. So now we have radiation exposure. In order to be service connected for radiation exposure, both of these must be true. The veteran must have an illness that the VA has a list of illnesses believed to be caused by radiation, or that the doctors say may be caused by radiation, and the illness started within a certain period of time after their discharge and their radiation exposure. The veteran must have had contact with ionizing radiation in one of these ways while serving in the military. They were either a part of the atmospheric nuclear weapons testing, or they served in the post-war occupation of Hiroshima or Nagasaki, or were a prisoner of war in Japan, or they worked as an X-ray tech or in a reactor plant or in a nuclear medicine or radiography while on active duty or during active or inactive duty for training in the reserves, or they did tasks like those of a Department of Energy employee that would make them a member of the special exposure cohort. You can Google that 42 USC 7384 Lima 14, and it'll give you some more information on that. Veterans may also qualify for disability benefits if they served in at least one of the below locations and capacities: part of underground nuclear weapons testing at Amchitka Island, Alaska, or assigned to a gaseous diffusion plant at Paducah, Kentucky, or Portsmouth, Ohio, or Area K-25 at Oak Ridge, Tennessee. Now you have the prisoners of war. These claims are worked by specific VA employees at each regional office, and they do require special handling. Former prisoners of war who are diagnosed with any of the conditions in the categories below are presumed to be service connected for those conditions, regardless of their length of time in captivity. Osteoporosis on or after October 10th, 2008, if the POW has PTSD, a neuropsychiatric disorder, including psychosis, dysmic disorder, which is also considered depressive neurosis, or any of the anxiety states, for example, like PTSD, a cold weather injury, traumatic arthritis, stroke, or heart disease. And then the following additional conditions are presumed to be service connected for POWs who were captive for 30 days or more. Again, osteoporosis on or after September 28th, 2009. Nutritional deficiencies included antivitaminosis, beriberi, malnutrition, and pellagra. Helminthiasis, peripheral neuropathy, and digestive disorders, including peptic ulcer disease, chronic dysentery, irritable bowel syndrome, and cirrhosis of the liver. Gulf War environmental hazards. So if you had contact with certain environmental hazards while serving in Iraq, Afghanistan, and other areas, you may have illnesses or other conditions believed to be caused by these toxic chemicals in the air, water, or soil. You may be able to get disability benefits if you have an illness or other condition believed to be caused by your contact with an environmental hazard and while serving in the military. This may include contact with particulate matter or large burn pits in Iraq, Afghanistan, and Djibouti in the Horn of Africa, a large sulfur fire at the Mishraq State Sulfur Mine near Mosul, Iraq, hexavalent chromium at the Karmat Ali Water Treatment Plant in Basra, Iraq, or pollutants from a waste incinerator near the Naval Air Facility at Atsugi, Japan. And now we're going to go into some basic presumptive disabilities. So there are certain medical conditions or disabilities that may be granted service connection on a presumptive basis if those specific conditions are diagnosed to a compensable degree, meaning at least 10% within a certain time frame after discharge from active duty. Most recognized disabilities must be diagnosed to a compensable degree within 1 year of discharge from active duty, for example, like the diabetes and hypertension. However, multiple sclerosis must be diagnosed to a compensable degree within 7 years of a discharge from active duty, and ALS can be diagnosed at any time after discharge from active duty and receive benefits based on a presumptive service connection. So now we're going to talk about a non-service connected pension. All right, so this is a needs-based benefit for wartime veterans, their spouses, and their children. So for qualifications, again, you're going to need to have that honorable or general discharge, wartime service. That does not mean you had to deploy to the war zone. It just means that you had to serve during a period of wartime. A disability qualification, meaning one of the following: either permanent and total disability due to non-service connected disabilities, or at least 65 years age or older, or be a patient in a nursing home for long-term care for a disability, or be receiving Social Security disability or supplemental security income. You need to submit a copy of your private and/or VA treatment records if you have them for your claim, if it is based on a permanent and total disability. And then you must meet the income and net worth requirements as well based on your household size. You'll need to submit VA Form 21P-527EZ. That is the pension application. You'll need to submit all receipts or documents for your medical expenses that you pay out of pocket. And if you are in a nursing home or an assisted living facility, submit a letter from the home outlining the services they provide and that monthly cost to you. So this concludes our presentation today on the service-connected and non-service connected benefits. If you want to apply for our services, you can apply by calling 1-844-400-VETS. That's 1-844-400-8387. Or you can email us at vethelp@lonestarlegal.org, or you can go to our website at www.lonestarlegal.org. Are there any questions at this time? Does not appear that we have any questions. We would like to go ahead and thank our funders. We'd like to thank the Legal Services Corporation, LSC, the Texas Access to Justice Foundation, the Bob Woodruff Foundation, and the Texas Veterans Commission for their grants and allowing us to be able to operate and provide services to the veterans here in the Houston area and all the other counties that we serve. We want to thank all the veterans out there for their service to our country. And we hope that you all have a wonderful day and a happy Veterans Day tomorrow.